Hello and welcome to the Emerging Litigation Podcast. I'm your host, Tom Hagee. Today we're going to center our discussion around a recent article penned by one of our guests. Our guests will discuss recent court decisions and their effects on artificial intelligence systems that are trained on copyrighted materials. They're going to discuss the four-factor analysis as applied to large language model training. We're going to talk about how courts address digitizing legally purchased books for internal AI training in contrast to building collections from illegal sources. The article that I refer to also covers questions related to market effects, licensing revenue, dilution caused by AI-generated works. Our guests present information for AI developers, copyright owners, and model users, including the importance of lawful sourcing, data set review, and output controls. Who doesn't have good output controls? Well, you might not. And legal precedents developing in this area, of course. That's why we're talking about it here on the Emerging Litigation Podcast. It's my pleasure then to introduce my guests, Ryan Phelan and Tiffany Gehrke. They're both recognized thought leaders in the fields of emerging technology law and artificial intelligence. And they're both partners at Marshall, Gerstein, and Boren. And they have appeared on the Emerging Litigation Podcast before. Can you imagine? They're very willing to share their insights and expertise with a wider audience, and that's what I appreciate about them. Ryan Phelan, partner at Marshall Gerstein. I'm going to say it right, Marshall Gerstein and Boren. He's contributed and written extensively on digital innovation, including intellectual property, such as patent and copyright issues regarding cutting-edge AI systems. He earned his JD from Northwestern University's Pritzker School of Law and an MBA from Northwestern's Kellogg School of Management. And he's also the author of the article that inspired this episode. Tiffany Gehrke, also coming back. Glutton for punishment. She's known for her expertise also in intellectual property, technology policy, and her advocacy for balanced and ethical approaches to AI regulation. She earned her law degree from Loyola University, Chicago School of Law. So together they bring us a lot of insight and academic rigor to conversations on the evolving legal landscape. Here they are, Ryan Phelan and Tiffany Gehrke. Hope you enjoy it. Ryan and Tiffany, thank you very much for coming back to the Emerging Litigation Podcast.
Great to be here. Thank you for having us.
Great to be back.
Okay, so Ryan, so the first one's to you. We're going to talk about some landmark decisions. As I said in the introduction, this is based on an article that we will link to that in the show notes and in the summary. So can you summarize the main findings? You're talking about Bartz versus Anthropic, and I think it's Cadre versus Meta, and explain how these cases influence the current understanding of, what is fair use in AI training and copyrighted materials.
Sure. Thanks, Tom. Yeah, so these cases are first of their kind and pretty impactful in the copyright world, at least. And what people have been wondering for quite some time is, how can these large language models that we've seen crop up in recent years, such as ChatGPT and cloud and all of these things, how can they take information from authors without their permission and use that to train their model? And if they do so, is there any recourse by the authors through copyright law for these model trainers, or is these model trainers have in fact some kind of defense in the copyright law called fair use, which is a common defense used in traditional copyright cases, but how does that apply in our new digital world, especially with AI? And so the interesting thing is that these cases involve two different sets of plaintiffs and defendants, and the cases are both in the Northern District of California. It's the district court there. And the cases were decided by two different judges of that court. So the judges had the opportunity to explore similar issues, in the copyright realm, and come to their own conclusions. But they, in fact, came to very similar conclusions and rulings, but one did have some criticism of the other. We can get into that later. Yeah. But and I'll refer to the two cases as the defendants, just because they're more widely known, as Anthropic being the first case and Meta as the second. And what happened in each one of these cases is each one of these defendants, Anthropic, and Meta has a model. Anthropic has their cloud model, which is very famous. Meta has their Llama model. And both of them did similar things for training that the authors did not like or approve of. And they took book data, book information, and used that to train their respective models. In one instance, they took books and scanned them in from books that they had purchased. They stripped off the covers and chopped out the headings and the page numbers and stuff like this. But they took the text of the books themselves and used it to train. And then they also got some shadow libraries or pirated books too, and also used that in their data. And the authors' theory of liability under copyright was that both of those two things constituted copyright infringement, and the model owners, the defendants in each case, raised the legal defense of fair use in order to defend themselves, in order to state that even though that they did do that, they did take and use that material, that it was fair use, and therefore they were not subject to the copyright law.
Right. I'm sorry, I'm laughing. It's like I never really, they were literally copying materials, which, it's right in the word copyright. You know what I mean? But that's not, that's just me playing with words. But because that also interests me too as a writer. I'm relying increasingly on AI, and I always want to attribute everything. And so it always makes me a little nervous. Are they, am I not attributing something by accident to something that maybe somebody copied in for training? They're not publishing it, but they did use it to train. So this is interesting to me personally too. So Tiffany, over to you. So let's talk about, Ryan's mentioned fair use. So let's talk about transformative use and fair use. How did the courts define transformative use in these cases? Why is this critical for fair use assessments when it comes to AI training?
So I thought the Anthropic case was particularly interesting here because the judge went through painstaking efforts to describe what they view as the transformative use. And so they talked about first that each work was selected and copied from a central library to create a working copy of a training set. Then the second step they said that happened was that each work was cleaned to remove some of the information like page numbers and, headers, footers, that kind of thing. Third, they then took each cleaned copy and translated that into a tokenized copy where they messed with the words, right? They might have changed the stemming of a word or grouping different characters from, letters and words together. And then the fourth thing they did was then they each fully trained LLM then itself retained a compressed copy of the work that they had trained on. And I thought it was interesting that the judge in this case wrote out each of those steps to help to inform, all of us readers that here's what I'm viewing as transformative. You took this thing, you did 1, 2, 3, 4, and then here's what the end was. And so that's what that judge said. Those are the steps that made this a transformative use. In the Meta case, I felt the judge was just like, yes, this is transformative. It's not a book. We're taking it and we're using it for training of LLMs, and therefore it is transformative. And for each of those, they did discuss that it's only one of the 4 steps of fair use. But in each case, they found it in favor of the large language models, that it was transformative and weighed in favor of fair use and against infringement.
Okay. Gotcha. Interesting distinction. So on to data legitimacy. Ryan, so why did the courts distinguish between lawfully obtained and pirated training data? What's the practical impact this might have on AI data sourcing in the future?
Sure. So, copying, from different sources is important because, the copyright infringement can be found when when and where you copy. So first of all, when you copy information from model training, you have to stick it somewhere like on a memory of a computer. And then, once you have the the books and the memory, then you can train your model, and then perhaps the model can output something that's the same or substantially the same, which would trigger, copyright infringement. The courts were, with respect to pirated versus non-pirated data, they were focused on the first of those, where you're just copying the information originally and sticking it in your memory and the computer memory for training. And so the courts seem to be saying, like, we don't care like how much transformative use you may have done after the fact, after you've copied the pirated works. Like, copying pirated works is never okay, and there's some explaining to do. They didn't get into that in their rulings, because it was there were motions for summary judgment. They were they talked about dismissing the case, and they did dismiss the case under fair use. In each court did this. They dismissed the infringement under summary judgment for the legitimately copied works from the books that they had, presumably under a first sale doctrine defense, because they had obtained the books lawfully. But for the pirated works, when those were taken and stored in the memory, they did not dismiss those counts based on summary judgment. That's to be decided later during trial, and presumably made an Anthropic or not looking forward to that.
Okay, all right. So, how did the courts evaluate whether the AI inputs were substantially similar to the copyrighted works, and what evidence is most important for determining infringement risk going forward, Ryan?
So there's along the lines of what I just mentioned, there's two ways that you can be found infringing copyright for AI training. The first is when you initially store that information in the memory, and then the second is the output. So you're kind of focusing on the inputs and the outputs and looking at infringement at that manner. For the second of these, it was interesting that the authors did not allege or did not, fight, at least in the summary judgment motion, that the outputs were infringing. Presumably, they could not create, output that was similar to a book. Let's say you had a book, that was in the lawsuit, and it had like a paragraph in the book. Presumably, the authors cannot get the AI to output the same paragraph, or at least substantially similar paragraph. In fact, in one of the cases, one of the defendants, I forget which, I think it was in Meta, they had an expert try to output a same amount of text from one of the books, and that expert was only able to output 50 words at most of the output, basically trying to. And basically argued on behalf of the defendant that was not sufficient. It wasn't enough to have, one of the fair use doctrine was that you have to take part, or, substantially all, or like what portion or how much, like quantity aspect of it. And she could not substantiate that, the expert. And so both of the courts were eager to address this issue. Like, can your model output the same sentences or lines or phrases of the actual underlying works? And the courts indicated that they would have been very eager to address that. That was the case, but that was not raised. So that second, copying, was not, was not at play. And it, you can, it's very hard, I guess, in the textual realm to do that. Other cases that are, still ongoing, like the Getty Images case, it's more easier to show a similar output. In fact, in the complaint in the Getty Images case, you have two pictures side by side of soccer players, and they both, the real image has like a Getty watermark on it, and so does the output AI image seems to have a Getty watermark on it too. And the question is, like, why would your generated Getty image have your generated AI image have a Getty watermark on it if it wasn't trained on, Getty real? And so it's kind
of a giveaway.
Yeah, and so here there's not that telltale giveaway, and so presumably the authors didn't do that. But going back to the original question, the first of those was focused on when that information was stored, and the as Tiffany had mentioned, they had transformed that stored data in so many ways that it was not deemed to be a copy because the information had to be transformed down to the token level, which, if you're thinking about the English language, tokens are like syllables and words. And those are, much different from the original text compared to the tokenized version of that text for model training was considered to be significantly transformative. And so was the output, by the way. And so that was one of the reasons that turned the court's decision for fair use. They both said that it was highly transformative in nature.
Okay.
I have two thoughts on what Brian just said that I'd like to share. So the first was when you were just talking about the Getty case, that made me think about really the difference in visual versus written, copyright protection and expressive works. And I'll be curious to see how this goes over time as we're talking about things that are text. So it can be jumbled up a little bit more that you might not catch it on the output side. Whereas your example with Getty, where they could see the watermark on there, I think that's really powerful. And it's, a little bit more of an indicator that you know where it probably came from, right? Whereas with words, you don't always know that. You don't have that indicator on the outside. So I think that's a really interesting case to be watching as well. And thanks for sharing thoughts on that, Ryan. The second thought was in the case with Judge Alsup, he repeatedly said throughout the opinion, basically, we're only focused on inputs here. The plaintiffs haven't really alleged anything similar on the outputs. And it was mentioned enough times throughout the opinion that it made me think, is he trying to signal he might have found differently if they had talked about the outputs more? I'm not sure on that because, in that opinion, it also came down pretty pro LLM. But I thought it was interesting that it was repeatedly mentioned throughout the case.
I took that both judges kind of mentioned it throughout their cases as kind of like a hint, nudge, nudge for future.
Yeah.
Please do this so we can, discuss this, the outputs. It just wasn't explored, but both judges seem to be eager to talk about it.
And the second judge even went so far, I think it's to maybe somewhat bolder than even a hint, and basically said, like, if they had put this evidence in, they might have had a winning argument.
Oh, wow. Okay. In your careers, have you seen judges do that, the nods and the winks, and need I say more kind of a thing? I mean, I've only seen it recently, like Supreme Court, opinions and dissents is saying, what you really ought to be doing. So I'm wondering, have you seen that in your careers with judges doing that?
Yeah, all the time. It's called dicta. Usually they'll
dicta.
say
Okay,
stuff
of
like
course.
that, and you could have done this. I mean, they're not supposed to do that. It's supposed to decide on cases and controversies, but it happens. So.
That's right.
And I think in these types of cases right now too, where they know there's a lot of eyes on them and they're probably going to get appealed up, I think we are seeing it more. It's starting to trend, trend that direction.
Yes. Okay. Yeah. Thank you. That's interesting. So Tiffany, we're going to come back to you. How did the courts reconcile the strong protection for expressive works like novels and plays with their fair use findings in AI training contexts?
Yes. So the courts really seem to focus on the fact that the books were focusing on the large language models were focusing on using the books for input. So they were, saying these weren't going to be, creating another book to compete, at least initially, right? That's where we get to the output discussion that we had earlier. The courts were instead focusing on, although we want to protect books, we want to protect authors, we don't see the training of the model as something that's harmful to authors. At least that's what I saw from the judge in the Anthropic case. I found the judge in the other case, though, to be more sympathetic towards authors and wanting to protect them and talking about using copyright law to incentivize authors to create and to protect those creations? And how do we make sure that we continue to incentivize creation of expression works by humans versus having the LLMs create their own expressive works that may or may not compete with or dilute the marketplace for, the original human being authors?
So back to, let's say, commercial use and copyright. So why did the courts allow even commercial AI training uses to qualify as fair use? And how might this reasoning affect future IP policies and litigation? Tiffany?
I think they did it here because both courts acknowledged just how transformative the training of the model use was. And they thought, well, in that purpose, it's okay, even if it is commercial in nature. And, in the Meta case, the judge also went on to say, I thought they did a nice job describing it here. So it said, the plaintiffs in the Meta case acknowledged that the large language models have end uses, including serving as tutors, assisting with creative ideation, and helping users generate business reports. And that several of the plaintiffs testified that using the large language models for various purposes were all distinct purposes from creating or reading an expressive work like a novel or biography. And because those functions were different from the functions that the books were going to be used for, for reading and enjoyment or learning, that they thought copying the books as a whole to develop this tool was in fact going to create a different use, even though it was a commercial use.
Developer practices. How do you think these rulings are going to shape how AI developers manage training data? And what steps should organizations take to minimize legal risks and comply with copyright law?
Yeah, I think that this sends a strong message to AI model developers that they need to use, purchase licensed legitimate data and not, pirated data. In fact, we've seen in the news recently, Amazon agreed to pay, I think, $10 million to the New York Times to license data from, the paper for, presumably for use for training purposes. And so model developers are going to be very careful about where they get their data from, hopefully from licensed sources, hopefully from sources like books that they've already purchased so they can rely on like first sale doctrine where, if you own it, you can use it, similar to, what we all know from, the days of buying CDs and stuff like that. You'd have a first right sale on like the music on that CD and couldn't get sued by copyright. So they're going to want to do something similar to that. So I think that was the lesson learned for them. I think the big surprise was that, the courts did consider it highly transformative and they just need to make sure that their data is clean.
Yep. Okay. Industry challenges. So what challenges or responsibilities do these rulings create for companies using AI and copyright owners? Are there collaborative solutions or industry standards that you would recommend or look to?
Yeah, I would say that, for copyright owners that have proprietary data, secret data, they will certainly want to protect that with like an NDA before they share it and they license it. The problem in these two cases was that the data was publicly available, right? The authors wanted to sell these books. They wanted them to be public so, they could sell their books and information to users. And so they're highly public and, they simply cannot have proprietary data in that case. So I'm sure they want to seek a license with the model trainers in order to get some type of revenue stream. I know that there's a bill currently floating in Congress that allows authors to have protection with respect to the works, that they get some kind of licensing revenue for, if their model is, or if their data is used, and perhaps some control over whether their data is used for training. Although I think that's only one of the two houses. I don't think it's, advanced very far. And whether or not, the president signs that into law is also another thing. The president was on a podcast recently with the AI developers, including, the hardware manufacturers, NVIDIA, and then also some of the AI model developers, including OpenAI. And he seems pretty AI model friendly, so to speak, where the current administration believes that training AI models and developing them is an important strategic objective for competing with other countries, including China. So, whether or not he would sign a bill that would limit AI use and protect authors is questionable. In fact, I believe on the podcast, he said that he did not want to entangle or have the AI model developers sued by authors because that would supposedly hamper their desire or their ability or speed to develop these AI models or be competitive as a country compared to other countries.
This is evolving. The litigation's evolving. Obviously, the technology is evolving rapidly. People are using it with various skill levels. People are bumbling through it. I'm right in the middle of it as a writer. Early days, it did make up 4 cases that I was looking for. But fortunately, I'm used to checking and rechecking things. And I even worked with a paralegal out in California. He's a very good paralegal, and he's a master researcher, and he's like, well, no, I don't think so. Maybe they were in some little court in some county in Texas that you're looking at. And I said, well, this is an antitrust case. So they're not going to be in a very, a small town municipal court or something. So, and I do know at least one, I don't know if it was attorney or the firm was fined in Florida because infamously put in some cases that were completely made up. I mean, who doesn't check those things? But anyway, it happens.
Apparently, a lot of the people don't check those things. I see almost every week some court somewhere is angry or sanctioning an attorney for filing a brief. Had made up citations. So, in fact, saw a article this week about attorneys proposing a fix where there would be an automated tool to scan briefs filed to see if there were any made up citations, which I thought was amazing that courts would even consider or do that.
Have AI check the AI?
Yes, I think that's smart. I do. I think that's very smart. I've started doing that a little bit myself, but I think having AI, search for itself. I think that's brilliant. I mean, that's a good use of it.
It's also kind of flies in the face of the ethical rules that attorneys should be subject to. So I think there's a debate there, but I don't have a solution.
We can come up with all we want. You can't. I can, because you represent people and you have clients. Nobody cares what I think, but it is interesting. It's fascinating as a writer, especially in law, where I spent my 20s and a good part of my 30s as a legal reporter, and I was reading a lot of court opinions. I mean, thousands of them, and the time it took to make sense of a case. You guys know it takes time, and I'm looking at Adobe and Copilot, which I guess Microsoft, they've got a partnership with ChatGPT and all this. You give them a document, it does a really good job of hitting the highlights for you if you need to understand it quickly. And the cool thing I like about that is there's no making anything up because it's got the document and it's got where it got the information. So, you know what I mean? So you can treat it like a junior writer or something. So there's super, it's just super pros and cons, but I'm enjoying learning about it. But enough about me. So what do you expect in future litigation or legislation? Ryan, you mentioned something that's in Congress now. I feel like they're focused on other things. I don't know. I read the news once in a while. Looks like they're up to they're busy with other stuff. What do you expect to see in the future?
There's a federal bill that I mentioned that certain congressmen and women are concerned about authors and their works being used to train these models and to make sure that they're compensated in some way. So whether or not that bill is successful or gets changed or is ultimately signed is anybody's guess. The states are also coming up individually with their own frameworks for AI, and it's kind of the Wild West right now with respect to what protections states are offering. California is considering some. Other states are also considering some. There's also a big push. And this is tangential, but there's also kind of this data privacy slash digital what's the word, a digital twin of people, like making sure that your appearance is kept free of usage. A lot of these cases come from the use of AI to
your image and likeness.
Thank you. Image and likeness, where people AI to put somebody's face on somebody else's body, with or without clothes. And so it's, states are, putting laws into place to protect individuals from that. So.
Yeah. There's some pretty sophisticated tools that are, some of them are hysterically funny. Some of them are just very funny. So it's amusing, but on the other hand, it's dangerous. I see things and you got world leaders making declarations, and it's very convincing, and it's not them at all. It's just very scary. Tiffany, what about you? Any outlook for the future?
Yeah, I think on the litigation side, so I think both of the cases that we primarily talked about today are both going to probably be appealed, right? But broader than that, I think the message is that future plaintiffs in these cases need to focus, broader than just training without permission or, seeing if the output can generate the exact text. And they need to focus on what both judges here signaled is important. And that are the output of the large language models going to create materials that compete with the authors and the underlying protected works? Yeah. Or are they going to dilute the marketplace? Or that, what's going to happen on that output? And plaintiffs need to focus on that. And then my last thought, I thought from the judge in the Meta case had a nice little succinct soundbite where they basically said, these products are going to generate billions, if not trillions of dollars. And if using copyrighted works to train those models is essential, then they need to figure out a way to compensate the copyright holders for it.
Yeah. As I'm listening, as I'm thinking about it, I feel like maybe you guys have an opinion, but I feel like the people that are going to be most threatened by this or squeezed by this are the creative folks, because writing is like, I can say write something in the style of Kurt Vonnegut and it'll get pretty good. And it's 10 years from now, it's going to be amazing. You're not going to know the difference. Or make a painting that looks like a Van Gogh and it's going to look amazing. And with printer technology, what do you call the 3D printing? And I'm sure there's technology that does painting.
Yeah.
I've never seen it, but I'm positive it exists. So I think the creative people are going to get squeezed on one side, and then what they do create is going to get potentially diluted or used or just transformed. And so I feel like the creative people are going to be under pressure here. I don't know what you guys think about that, or I don't know what to do about it, obviously, but.
Yeah, I agree. I think both sides need to figure out a working solution going forward, because I think the advances in technology that can be gained through this are incredible and are very powerful.
Yeah.
But I agree that you want to continue to incentivize the next great authors to create novels, to feel comfort in doing that, and that they would be protected in the future. And so I think there's got to be a balance that is struck here with compensation or other limitations. I don't have a great idea on what that will be yet, but I think it needs to get there.
Well, let's come up with it. Ryan, you have a solution, don't you?
The closest solution I've heard, which, I don't know if it is something akin to what happens in the music world now, where now music is, authors don't receive a license directly. They, kind of goes into this collective, system where, maybe per play of their song, they get a fraction of that. And then, and so there's, kind of the Spotify model, so to speak, is what I've heard. How that plays out with model training could be different, because people aren't, once you train the model, it's trained with the information. It's not like people are listening to the information again, right? The model's not listening over and over, unlike, people listening to songs over and over. So there's similarities, but there's differences. But there is, this aspect of authors creating material and that having an input into some, larger model or system, and then the authors getting compensated for that, which, seems to be the way to go. Otherwise, you get to a world like, Tiffany suggested, where authors are just not incentivized to, create new things, and the AI is just learning on, its own output, and therefore everything
Right.
starts to look the same and sound the same. And, there's nothing new to the world. I guess I'll be old and dating myself if I say this, but I can remember the music back from 2 decades ago is quite different from what we have now, and I don't know if the Spotify model has impacted that, or if I'm just old and I like the music from 2 decades.
Well, I mean,
but maybe we enter a world like that if we don't incentivize enough creative talent to create new good art.
it speeds up in terms of music. It speeds up what humans would do too. They would hear the Beatles, and the Beatles would influence another band, and they would influence another band. And pretty soon you get very it goes in different directions, kind of very superficial, derivative. People do it, but AI will do it faster. So you get this great music that turns into becomes an elevator music. So it's going to be interesting to watch. I've got a nephew who teaches creative writing in Wisconsin, and writing, creative writing, and just other kinds of writing, expository, and it's a real challenge. And he's very good at spotting what is AI language, and as am I. In fact, somebody who specializes in this sent me a list of words that Google algorithms look for to see whether something is AI written. And there are some so I'm writing about law, and you guys will appreciate this. I ask it, give me a summary of a case, just so I can know what it was. And then it'll spit out, so you want me to do a blog? I said, sure, write a blog, see how it does. In this landmark case, every case is a landmark case. Right. And even some of the notes I did for this, it uses the word landscape, the legal landscape. It's always landscape, and it's a landmark. So I've got a whole list now of words that I have to avoid. It's awkward because some of them are words you would normally use. Tiffany and Ryan, thank you guys very much.
Yeah, thanks for having us.
Thank you, John.
The Emerging Litigation Podcast is a production of Critical Legal Content, which owns the awesome brand HB Litigation. Critical Legal Content is a company I founded in 2012. What we do is simple. We create content that's critical on legal topics for law firms and legal service providers. That kind of content can be blogs, papers, they can be podcasts, webinars, and we have a good time doing it. And as for HB Litigation, well, that's the name under which we publish interesting, at least interesting to me, legal news items, webinars, articles, guest articles, all on emerging litigation topics. Once again, I'm Tom Hagee with Critical Legal Content and HB Litigation. If you like what you hear and you want to participate, give me a shout. My contact information's in the show notes. Thanks for listening.